Good afternoon and morning. Welcome to another webinar hosted by the America Europe Chair on Technology, Innovation and International Regulation. My name is Esther Ozalen Adu, and I will be moderating today's discussion. Before we start, I would like to mention a few words about this chair. The America Europe Fund strives to be a platform that supports academic cooperation, exchanges, programs, and research to disseminate and strengthen comparative knowledge of European and American societies. One initiative that supports our mission is the American Europe Chair on Technology, Innovation and International Regulation, which aims to provide interdisciplinary research and expertise on regulatory developments in Europe and America with a focus on technology, innovation, and international regulation. Through these activities, we promote opportunities for cooperation and dissemination amongst stakeholders across the Atlantic. In today's discussion, we are joined by Ms. Annelien van der Meulenbroek, who is a partner and heads the digital and data protection team at Ubilis in Brussels, Belgium. In the US, we are joined by Mr. Julian B. Flamand, who is a senior associate on the global regulatory practice at Hogan Lovells, US in Washington, DC. In today's discussion, we'll pass through the latest saga revolving around EU-US data transfers, particularly the impact and future of the current legal framework, the EU-US Data Privacy Framework. The framework marks the EU's third attempt to facilitate EU-US data transfers with sufficient safeguards and legal remedies for EU data users. However, within months of its passing, the framework faced a legal challenge at the Court of Justice of the European Union. Although the court dismissed the claim, it still raised questions as to the efficacy and longevity of the framework. To understand this discussion, I would like to ask a panel about their thoughts on particularly what key events or cases led to the invalidating of the previous framework known as the EU-US Privacy Shield. And we'll start with Annelien.
Yes, thank you, Esther, and thank you, America Europe Fund, for the invitation to participate in the panel discussion of today. I think the question is not exactly what key event, but maybe who has led to the invalidation of the previous framework of the Privacy Shield. And a name that is very important in the topic that we will be discussing today is, of course, the name of Maximilian Schrems. He is an Austrian former PhD student and a privacy activist. And I think before we talk about his actions that led to the invalidation of the EU-US Privacy Shield in 2020, it's worthwhile to have a look at the first Schrems judgment as well, because the invalidation of the Privacy Shield was done through the Schrems 2 judgment, but Schrems 2 also indicates that there was a Schrems 1 judgment. And in order to fully grasp what was at stake, it is important to understand at how we look in the European Union to personal data and the free flow of personal data. So we have this principle in the European Union that data can flow freely, that they're safe within the European Union, or I should even say the European Economic Area. And that's because these data are protected. They enjoy the protection of fundamental rights that are enshrined in our primary and secondary EU legislation, but also in instruments like the EU Charter of Fundamental Rights. And once data are leaving the European Union or the European Economic Area, we're not sure anymore that they can enjoy that same kind of protection. And yet we are faced with global economies that require that data can flow throughout the world. So we needed to come up with a solution. And that solution is actually to be found in Chapter 5 of the GDPR. And that includes some data transfer tools that in a way, I would not say artificially, but that creates a level of protection that is essentially equivalent to the protection that we have in the European Union. And two data protection tools or data transfer tools that are important for the discussion of today are, first of all, the adequacy decisions And the DPF, the Data Privacy Framework, is an example of that adequacy decision. And on the other hand, I think we will also briefly touch upon standard contractual clauses is also an important data transfer tool. And an adequacy decision, to understand what it is an instrument, it is a decision of the European Commission that is actually saying that a country, a third country outside of the EU, outside of the EEA, has legislation and has a judicial system that provides protection to personal data from EU citizens. And so far, since 1995, since the Data Protection Directive, we have a number of adequacy decisions for countries like Argentina, Andorra, Canada, Israel, and I think maybe Julian will touch upon that adequacy decision later on, Israel as well. And recently also countries like Japan and South Korea. Just to briefly explain the other tool, standard contractual clauses is not a decision of the European Commission. It's actually a contract between a data exporter in the EU and a data importer in the US or another third country, whereby the parties agree to contractualize actually the protection of the European Union. And now back to the United States. The United States has a very particular history when it comes down to adequacy decisions. And that is, I think, in the first, primarily because the United States does not have a federal privacy and data protection legislation. There is no such thing as one data protection legislation like we have in the European Union, where we have one rule, one ring to rule them all. And so adequacy in the United States is organized a little bit differently. Adequacy is organized for those organizations in the US that have self-certified under a set of principles that are kind of alike to the principles that we have under the European Union legislation. And so far, we have had 3 frameworks. Esther was already mentioning it. We had the framework of Safe Harbor of 2000, which was invalidated in 2015 with the first Schrems judgment. There he is again. So it lived up for 15 years. And then after that, we needed to find a solution that was the Privacy Shield, which was born in 2016, but then was killed again in 2020. So it lives for 4 years. And now we have this data privacy framework since the summer of last year. And when we have a look at the arguments that led to the invalidation of the previous frameworks, then the main concern around this whole topic is actually the topic of mass surveillance that you can find in certain US legislation. Actually, the first Schrems case originated from the fact that Max Schrems was a Facebook user. He filed a complaint against Facebook Ireland in the aftermath of the revelations of Edward Snowden in 2010, that US was actually using mass surveillance programs. And he was saying, like, this framework that you have here, this Safe Harbor framework, it's actually not protecting my data against these mass surveillance tactics. And so he filed a complaint with the Irish Data Protection Commissioner, and that led up to the first Schrems case, where the Court of Justice actually confirmed that mass surveillance, like the US is organizing it, is not in line with the EU principles. And then that invalidation led to a new framework, Privacy Shield, in 2016, and soon we had actually a recast of that first case. And what is important is that in that second Schrems judgment of the Court of Justice, there are actually 2 key findings that are really important in everything that we will discuss later on. That's first of all, the continued concerns around US mass surveillance activities, whereby the Court of Justice is saying that those kind of bulk data collections is not limited to what is strictly necessary, is not proportionate, and it goes against the principles that are enshrined in Article 52 of the Charter of Fundamental Rights. So proportionality, necessity are really important principles that we do not see respected in US legislation. That's the first thing. And secondly, our EU citizens do not have actionable rights against those surveillance activities. If something happens, we as as EU citizens rather, we cannot claim something somewhere. So it's really difficult for us to find redress, to find a remedy if something goes wrong. And there it was found that the ombudsman system that was enshrined in the Privacy Shield was not sufficient. So those two topics, on the one hand, proportionality, and on the second hand, legal remedies, effective legal remedies, were at the core of the decision of the Court of Justice to annul the Privacy Shield in the second Schrems II judgment.
Okay, and thank you for that overview. So it begs a question, based on what findings or grounds did the Commission adopt its adequacy decision on the 2nd of July 2023, which led to the current framework? And I give that question to Julian.
Thanks, Esther, and thanks, Annaline, for laying out the saga that we've lived through, including with the two Schrems court cases. I think that's really an important starting point to talk about how the data privacy framework developed and also how the Commission was able to reach an adequacy finding with regards to the data privacy framework. Interestingly, the Schrems I decision really was that the European Commission, in its adequacy finding for the safe harbor framework, had not adequately considered the nature of U.S. surveillance laws in order to make its adequacy finding. So the court in that case set aside the European Commission's adequacy finding, leaving wiggle room for the Commission to kind of try again, to find another adequacy finding related to a data transfers framework where the Commission felt like it adequately assessed the nature of U.S. surveillance laws. Schrems II was a little bit different because the court went one step further and said not only was the European Commission's adequacy finding inadequate, but in addition, that the U.S. surveillance apparatus was inopposite with European fundamental rights, meaning that the European Court of Justice in Schrems II more clearly stated that the U.S. surveillance apparatus could not operate in compliance with EU fundamental rights. And the basis for that, as Annaline outlined, was that the European Court of Justice found that U.S. surveillance laws did not follow the principles of necessity and proportionality that are enshrined in EU law, as well as a lack of effective redress for European citizens whose data had been surveilled in a way that violates EU law. And so that's the redress piece. And so moving on to the establishment of the DPF and the European Commission's adequacy finding, what they were able to do was map changes in U.S. surveillance laws that had occurred following invalidation of Privacy Shield to basically find that those changes did fill the gaps that the European Court of Justice identified with regards to necessity and proportionality, as well as the redress mechanism, which is vastly different under the data privacy framework and the updated laws in the U.S. compared to the laws that were available under the Privacy Shield. So to talk a bit more about that, I think the piece to highlight, or that I always try to highlight, is the fundamental change to U.S. surveillance laws that happened in between the invalidation of the Privacy Shield and the establishment of the data privacy framework. That happened not through legislative lawmaking, but through an executive order 14086, which came out in October 2022, and was an attempt for the US administration under President Biden to fill those gaps that the European Court of Justice identified. And so EO 14086 kind of has a lot of pieces. The primary pieces are twofold. One is a set of substantive safeguards, essentially constraining the U.S. surveillance agency's ability to gather intelligence about foreign data subjects. So obviously, as applicable here, that would be EU data subjects, by requiring that any surveillance pursued by the US surveillance apparatus is necessary and proportionate to legitimate surveillance objectives, which had to be established and reviewed within the administration. And importantly, they had to be pursuant to legitimate objectives, and they could not be pursuant to objectives which are clearly prohibited in the executive order. And so it's important to note, which I stated earlier, that this is really a fundamental shift in US surveillance, because it creates all of these constraints on the ability for US surveillance agencies to go and get data that has been transferred about EU data subjects into the US. That's one piece. That's the substantive safeguards. With regards to redress, as Annalene pointed out, the issue that the Court of Justice identified under Safe Harbor was that there was this ombudsperson established within the Department of State who could review complaints from EU data subjects who felt that some kind of surveillance activity violated their fundamental rights to privacy. The issue was that that ombudsperson was within the executive branch and reported to the Secretary of State, which the European Court of Justice found was not the independent tribunal that European fundamental rights guarantee. And so under EO 14086, there's a two-layer redress mechanism allowing EU data subjects through their national regulator to send complaints directly to the Director of National Intelligence in the EU, in the US, to review any surveillance activities that they think could violate their privacy rights. That's one level, that's one layer of the redress mechanism, is this review by an office within the Director of National Intelligence. There's then a second layer of redress, which is an appeals process through this new tribunal, which is the Data Protection Review Court, which is established within the Department of Justice and is composed of independent judges, and as well includes special advocates that are available to advocate on behalf of EU data subjects. I'll also just finish by saying there are additional protections in EU 14086, such as new data minimization requirements. And also, while it still allows for bulk collection of intelligence, there are additional restrictions where intelligence agencies rely on bulk surveillance. And so the view of the US government, which has been mirrored by the European Commission in its adequacy finding, is that all of these gap-filling pieces sufficiently address the shortcomings that the European Court of Justice identified with the Privacy Shield adequacy decision.
Thank you, Julian. And that kind of leads to my next question. In your view, does the current framework adequately address the shortcomings identified under the previous regime? And this could be especially from a perspective of a data exporter or data importer. We'll start with Annalene and then Julian.
Yes, thank you, Esther. I think now it will become really interesting. So being the EU practitioner, I will voice the point of view of a data exporter. And it's not my personal opinion that I bring here, but I rely on some documents that have been prepared in the path leading up to the adoption of the Privacy Shield. And there have been important documents that raise a number of concerns that I will explain to you. First of all, in order to be able to adopt an adequacy decision, the European Commission needs to ask the opinion of the European Data Protection Board, European Data Protection Board, which gathers actually the national data protection supervisors, and they have issued an opinion which is not binding, whereby they spelled out that there is definitely improvement in what we're seeing here. There are a lot of novelties. There is a new name to start with, but that's just a joke. But most importantly, there are improvements, like, for example, on the first concern, the principles of necessity and proportionality are now included in the executive order, which led up to difficult discussions. On the topic, the second concern of the effective redress, Julian has beautifully explains how the two-tiered approach works, and that two-tiered approach includes new safeguards for impartiality, independence, and so forth. But still, and that was also the conclusion of that opinion of the European Data Protection Board, concerns remain. These concerns on the first level of the necessity and proportionality are, for example, that what is meant by necessity and what is meant by proportionality. That is something that are two concepts that are fundamentally different under EU law and under US law. So we have that victory of having the words in there, but if the meaning is different, then it's not a big victory, you could say. That's a concern that is voiced. Another element that is often brought forward is the fact that, as Julian explained, the difference between the Privacy Shield and the DPF lies to a large extent in that instrument of the executive order, and the word says it itself. It's an order of the executive. It's not an act that went through Congress. It's an instrument of the executive, so it's always something that can be changed by the executive, and it's not something that can change existing legislation like there still exists in the United States, like visa and so forth. So that's a criticism that is also often made. And then we have, regarding the two-tiered redress mechanism, we have now a court, which was also very important in the reasoning that was spelled out by the Court of Justice in the Schrems II judgment, that we have effective legal remedies by impartial judges and so forth. But that court that we have now under the executive order is also something that is within the realm of the executive. It's not a full court. So these are some examples of concerns that were voiced by the European Data Protection Board. But all in all, the European Data Protection Board did not per se opposed against the data protection or the data privacy framework. We've also seen the same concerns being voiced by the European Parliament a little bit later in a resolution where it was a little bit firmer in its point of view and actually said, like, we cannot go through with this, you should not adopt the DPF. So I think there is, we are a little bit cautious at this end of the ocean of whether all of the initiatives that were taken to improve the situation will live up to the expectations of the Court of Justice.
Okay, and Julia, your perspective?
Sure, thank you. I mean, I think all of those points are the right ones to focus on in thinking about the potential longevity of the data privacy framework. It can't be excluded, you know, that there will be a challenge that eventually would be successful against it. Certainly the issues of defining necessity and proportionality are challenging. I think these terms are not well defined under EU law. And so it's difficult, you know, bringing those principles over to the US to find really clear definitions about them. What I will say, and I think this mirrors the European Commission view, is that, you know, at least as regards the executive order, there are kind of those safeguards making sure that there are really substantial limitations on surveillance activities. I think the other point to make is that because of the way this was done through an executive order, the safeguards that are in the executive order apply to all surveillance activities in the US, you know, not just where data is transferred through the DPF, but also where data is transferred through other mechanisms such as standard contractual clauses and BCRs. So this kind of creates an overarching limitation on the ability of U.S. intelligence agencies to go out and get data that has been transferred to the U.S. That's one piece. Another piece is with regards to concerns that this was done through an executive order rather than by a legislative mandate. I think a lot of folks are focusing on this point, but what I always think about is the fact that legislation also can be overturned, and particularly, to the extent that there are concerns that an executive would come in who could just repeal Executive Order 14086. I think that's a reasonable concern, but that could also happen through Congress, through a legislative act. The situation in our Congress is pretty difficult right now in terms of passing new legislation and finding consistency to actually get laws enacted. I don't see what the advantage would be to have a legislative act other than an executive act. The last piece I'll say about that is that it's not like it was just an executive order, and then there are these rules that are kind of operating in the background or that are sitting in the background but are not being operationalized. It's important to remember that the executive order creates a mandate for all of these executive branch agencies, and in particular the intelligence agencies, to reform their operating procedures to include these intelligence priorities and to include the limitations that are established under EO 14086. And that process has been done now. They had a year to do it from October 7th, 2022. So by the end of 2023, all of the intelligence agencies had to formally reform their surveillance practices. And then the last piece that I'll note is that all of those practices have been published. And so, any individual can go online and find the formal write-up of what those intelligence practices are. And so there's a key aspect to this, which is transparency. In addition to being able to use that redress mechanism, regardless of how your data was transferred, how an EU data subject's data was transferred to the US, there's also a fair amount of information out there about what the US government is doing when it uses signals intelligence activities. To me, this seems like a very strong framework. And I'm at least hopeful that it will be around for a while.
Okay, thank you so much, Julian. So that leads to my next question. What is actually the future of the current framework? And do you view that there could be a possible risk that it may be invalidated in the near future? In particular, you could highlight initial challenges or other private initiatives that have come up that could possibly provide an alternative. And I'd like to start with Annalene.
Yes, thank you, Esther. I think the risk of a challenge is real. We both highlighted it throughout the session already. It's been voiced by that person, Maximilian Schrems. He already announced that he is looking into how he can challenge things. And we actually already had a very concrete case before the General Court, which was initiated by Patrick Latombe. Patrick Latombe is a member of the French Parliament, and I think he's also involved with the French CNIL, who is the supervisor in France. And he challenged the DPF in a very particular way, using a very specific procedure that exists before the European institutions. He did a direct action of annulment on the basis of Article 263 of the Treaty of the Functioning of the EU. And basically, that is a procedure where you have to demonstrate that you are personally affected and that there's some sense of urgency, and that sense of that there's some kind of urgency that should lead to a suspension of the instrument. So he was asking a suspension of the DPF on the basis of some of the concerns that I was talking about earlier, and the fact that initially the DPF was only published in English, but once it was published in the official journal, that argument was over. And he claimed that he was affected because he was a user of products of Microsoft, US companies, Google, and so forth. But the claim was quickly dismissed by the general courts, but mainly on procedural reasons, so procedural motives, the fact that he could not really demonstrate how he was personally affected, what his prejudice was, and so forth, that led to the decision that the case was not admissible. So the arguments regarding the merits of the case were not yet discussed before the general courts. But I think regardless of this case, I think we will probably see new legal cases. If you read in legal scholarship, there is kind of a consensus that we will face a new challenge of this DPF. And what I see in my practice with my clients is that there are, for that reason, also a little bit reluctant to fully rely on the DPF. So they are really taking into account the chance that there will be a challenge, and that challenge will lead up to an invalidation, a new annulment. And especially in day-to-day issues for companies, for organizations, such as moving systems up to the cloud, IT migration systems, and so forth, where you need to think long-term. This is really important. And we've seen the first framework lasted for 15 years, the second for 4 years. We are now 1 year into the DPF, and we are already discussing its annulment. So it's not providing legal certainty, or not enough legal certainty, or at least for a large number of organizations. And so, yeah, I think, unfortunately, the future will hold a new case before the Court of Justice.
Thank you, Aline. And Julian, what's your perspective?
Thank you. Yeah, I mean, I agree with all of the points that Annaline made. I think challenges will continue to change and affect the way that data transfers are done. GDPR's Chapter 5, prohibiting exports to third countries is fairly strong. And so, I don't see a basis for which these would stop. And I think, and Aline made a great point, which is that companies are more hesitant to, to certify with the data privacy framework than they were under Privacy Shield. I think at its height, Privacy Shield had over 5,000 data importers who were members. I just checked, the data privacy framework is below 3,000. So there is some hesitation. And I think there's another piece, which is, in the meantime, we had a revision to the standard contractual clauses that a lot of companies, invested in adopting and went through processes with their vendors and with their customers to get those contracts in place. And some may feel that, they don't need to certify to the data privacy framework. We can talk a bit more about that later, but I do think challenges will continue. What I'll say, though, is that there's also a political component here, probably part of what's driving the challenges, but also part of what's driving adhesion to the data privacy framework, because the International Association of Privacy Professionals did a survey in 2021. So in the time after invalidation of Privacy Shield, and I think it was even before the new standard contractual clauses came out, and 10% of respondents there noted that they had to change, so alter in some way or fully stop some of their data transfers to the US. And so you can see the substantial impact that this has on the transatlantic digital economy. And so I think, we need to think about potential challenges as well in the context of, the political momentum here. I'll also say that the challenges can continue. It doesn't mean that the DPF is going to be invalidated. I mean, I think the US government really made a big effort to look at the gaps that the European Court of Justice found in the essential equivalence of the U.S. framework, in particular with regards to surveillance activities, and sought to address each of those pieces one by one. And so I'll just say the way that's been articulated by the EDPB are through the European essential guarantees. Those are that processing should be based on clear, precise, and accessible rules. Necessity and proportionality with regard to legitimate objectives need to be demonstrated. An independent oversight mechanism should exist, and effective remedies need to be available to the individual. I think we have all of those pieces in the framework that we've built over the last few years. And so there can be challenges. I'm not sure they can be successful.
Thank you, Julian. And as have been hinted by the panelists, we kind of wonder that, considering all these factors, what alternative frameworks or tools are actually available to US companies? And these could include practical considerations like finding corporate rules, impact assessments, or even priorities for clients. And we'll start with Andy.
I was muted. Yeah, maybe maybe it's interesting to first have a look at the concrete solution that the data privacy framework is, because it is still there. It is still a concrete solution, and it benefits the presumption of legality, so we can use it. So first, it's maybe interesting to have a look at that framework, and from the point of view of what it takes in practice to rely on the data privacy framework. And I can maybe explain what you need to do from a European point of view, and then maybe Julian, you can give the US point of view on that. But if, as an organization, a data exporter in the European Union, you would like to work with a data importer that is certified under the DPF, then first of all, you need to do a check of whether that is really the case. And that's something that we sometimes remark, that a company is claiming that it is certified under the DPF, while it is not, or not yet. So that's a first check that you need to do. You go to the website of the DPF, and there you check. You check also whether the data transfer that you're envisioning is in scope, because there are sometimes some limitations for HR data and so forth. So that's something that you need to check. And then if you go ahead, if you have sufficient trust in that, there's also an information obligation, a transparency obligation that you need to comply with, being the data exporter. In your privacy policy, you have the obligation under Article 13, 14 of the GDPR to explain if you're transferring personal data, on what basis you're doing so. And so if your basis is a DPF, then you should inform your data subjects about that. So that's briefly how you start up with DPF from a European point of view.
And Julian, in particular, do you have any perspective in regards to a viewpoint of a transfer, especially what kind of priorities are in place or factual conditions companies think about, especially when dealing with clients?
Sure. I mean, I think, this follows well from what Annalyn said, which is that there is an obligation to inform data subjects on the basis of your transfers. I don't think that forces you to use one or the other in all cases. You can use the DPF when it makes sense, assuming that you're transferring to an importer who's certified with the data privacy framework. But you can also still rely on the SECs, for example. I think that's the case that we see most commonly is transfers or exporters and importers deciding whether they can rely solely on the DPF or whether they would need SECs in some circumstances. There are good reasons to use SECs. For example, if you're transferring to an organization and you're not sure whether they would be DPF certified, or if you're kind of creating a governance program that will include a lot of different transfers, I think it's easier to say, well, we're going to put SECs in place for all of our transfers, and you won't have to do that assessment on a case-by-case basis. So there are some considerations there, though, which is that, you know, the DPF has a big advantage, at least for importers, right, who are based in the US, which is that the transfers would be subject to FTC oversight, the Federal Trade Commission, which is a federal regulator here in the States. Importers might find that it would be easier to interact with the Federal Trade Commission than it would be with you know, member state regulators or data protection authorities in Europe. Another important piece is that the standard, if you're using SECs following Schrems 2, you also need to do a transfer impact assessment, or a TIA, which requires you to assess transfers on a case-by-case basis to determine whether your use of the SECs effectively protect European data when it's being transferred to the third country. And so basically there's an additional documentation or an additional assessment requirement if you're using SECs that you wouldn't need to do with the DPF. And so what companies often are doing are at least have the ability to put in place both mechanisms to rely on the DPF when it's available, but then also backfill that with SECs in cases where they would be required. There's another big piece to consider, which is that the standard contractual clauses is a set of specific safeguards that are intended to fill potential gaps between European data protection law and the laws in the third country. We'll stick with the US in this case. Now, when the SECs first came out in 2021, almost all of the EU regulators came out and said, well, for transfers to the US, you need the SECs. In addition to that, you need supplementary measures. Those can be additional contractual protections, you know, such as requiring a specific encryption standard that you wouldn't otherwise need to require just under the SECs, or implementing additional safeguards, requiring the importer to implement additional safeguards internally. This can be a challenging area because your SECs could include a lot of supplementary safeguards, or your contracts could include a lot of supplementary safeguards that you wouldn't need to adhere to if you're just transferring or if you're just receiving data under the DPF. And so this is an area that, you know, we generally advise that companies pay particular attention to if they're using multiple transfer mechanisms.
So that leads to my final question. What is actually the future of EU-US data flows? Because the current framework is the third attempt. So do you see this as a concrete solution in the near future, or will there be something else? And Arlene, I'll give that question to you, and then Julian.
Yeah, I think what will be interesting is the review that is coming up this summer, where we will have a little bit statistical data, I would say, about the use of the DPF, which is more than our personal experiences advising clients. So that's something that we look forward to in the near future. As I already mentioned, it's the DPF is a concrete solution right now. It enjoys that presumption of legality, yet the momentum is also a little bit of a no man's land, I would say, and that legal scholarship is convinced that there will be challenges. And while we differ a little bit about the outcome, it will be very interesting to see what that brings. Maybe one thing that I now more regularly see in the debates around the data transfer problems is the fact that this problem is actually approached in a very absolute way. By that I mean that we try to approach data transfers from a zero risk point of view. As soon as there is some kind of risk that there may be surveillance or data collection by US entities, and that risk is always present, I think, then you're blocked. While an important element of the GDPR is also the risk-based approach, and the risk-based approach takes into account risks. It's not a zero-risk approach. So I'm looking forward to how this new line of thought in this whole debate will develop.
Many thanks. And Julian, what is your perspective on the future of EU-US data flows?
Yeah, I agree that the DPF currently is a concrete mechanism that will continue to be subject to challenge. Potentially SCCs will continue to be subject to challenge, at least when used to transfer EU personal data to the US. I would say that the impact of those challenges may vary based on what kind of organization you are. If you're a large multinational company that is often reviewing your data governance practices as more and more data protection laws pop up around the world, you might be less impacted if you sign up now for the DPF and it's eventually invalidated, in a few years' time, because you're probably updating your contracts and your governance practices pretty often. I know some companies are redoing them every year, and so they would have that opportunity to make another shift if needed pursuant to an invalidation. The DPF, though, is here, and it's something that companies can rely on. I also wanted to make a comment about the risk that Annalyn raised, which I think is really a great point to focus on, pursuant to Executive Order 14086, the risk of surveillance that will violate European fundamental rights is much lower now, because whether your view is that they fill every gap that the European Court of Justice identified in Schrems II or not, they at least do a lot to constrain intelligence agencies' ability to go and get data. And so if we're using a risk-based approach to look at potential, violations of EU fundamental rights pursuant to data transfers, the risks now are much lower. And that applies regardless of what transfer mechanism is being used. And so I think it's important not to lose sight of the fact, that we need transfers. I think, Esther, that's how kind of you started this webinar. Transfers will continue regardless, and we need a solution. And both governments in the US and in the EU did a lot of work to find this solution, and they've backed this solution, meaning that they feel that it's concrete and it's here to stay. And one more point I wanted to note, which relates to EO 14086, is that I discussed the redress mechanism that's available to EU individuals whose data is transferred to the US, regardless of what mechanism is used to transfer the data. So again, as I've said many times, EO 14086 safeguards and the redress mechanism applies to surveillance activities, regardless of what authority is being used and regardless of how the data came into the country. However, to be able to rely on that redress mechanism, the data subject needs to be located in a qualifying state. That's a state, or in this case, the EU, a political area, which the US Attorney General has found to qualify for use of this mechanism. Currently, the EU and the UK are determined to be qualifying states. There aren't any others. But my sense is that this is part of that political give and take, which is that probably, EU authorities wouldn't want to jeopardize having the ability of EU citizens to access that redress mechanism. So I think that will be an important factor, maybe in the background at a political level.
Many thanks, Julian and Annalyn. And with that, we now enter our Q&A session. We have an interesting question by Sylvia, which states the following. So she basically asked the question of what is actually the relationship between Pfizer and EU 14086, by stating, does the Pfizer trump EU 14086 still allowing data collection for foreign intelligence purposes, or is an EU ineffective amendment to those FISA principles? And she said it would also be interesting to situate this discussion, if time is allowed, in the EU data collection saga, and more specifically in the Quadrature du Net judgment. So who would like to try this question?
I think that's a question for Julian, since it considers US legislation.
Well, I'm here. We're a team, so that's
Okay.
great. Yeah, I'll comment on that since it relates to US law, and I'll just say, once again, that the EO 14086 safeguards apply to not to a specific law, but to surveillance activities. And so, for example, I'll put it in the context of FISA because it's a law or an authority that the European Court of Justice specifically referenced as one allowing bulk surveillance, and therefore, being inconsistent with European fundamental rights. So FISA creates many authorities for the government to seek information that is held by US companies. The one that's caused the most concern over time, and it's relevant to talk about it now, not only because it was a headline in the Schrems II ruling, but also because it just received reauthorization for a couple of years, is the FISA 702 authority. This authority allows surveillance agencies to seek approval not on a case-by-case basis for surveillance, but more broadly with respect to general activities. And so what they'll do is they'll get approval from a special court, the Foreign Intelligence Surveillance Court, to then use what essentially it's backed by the Foreign Intelligence Surveillance Court, but it really would operate more like an administrative subpoena, where the intelligence agency can go out directly and seek to compel a provider to disclose foreign intelligence information. So that authority has caused a lot of challenges in this space, but I just want to highlight again that all of these safeguards that are put in place would also apply to any surveillance activities that are done pursuant to FISA 702 authority.
Many thanks. And we have also another interesting question. As has been hinted, the permissibility of bulk personal data collection for intelligence purposes remains an open question, especially here in Europe. Has this issue been addressed under the current framework, or do you foresee that this issue will surface in the future, especially in future litigation, or do you see that this will be resolved via a political solution? Annalie?
Or maybe should I take that one as well, since it relates to bulk?
Sure.
Yeah.
Okay. So what I wanted to say is that the EO 14086 protections include a provision for bulk surveillance. It doesn't exclude the possibility for bulk surveillance, despite that being a key issue that the Court of Justice raised. However, it creates additional constraints that are specific to circumstances where intelligence agencies use bulk collection activities. And so these are really focused, bulk collection is limited to legitimate surveillance activities that are focused on protection, rather than seeking to understand the nature of a foreign government or a terrorist group in a foreign country. The six legitimate objectives for bulk collection are really limited to protecting the homeland and national security. And so there again, we see how there are these strict limitations that are in place for bulk collection, even though it's not excluded.
Yeah, and if I may, Esther, I was going to add something regarding the second part of the previous question that we had that related also to case law like Quadrature du Net. And there, the issue that was dealt with by the Court of Justice is actually the bulk collection of electronics communications data, but within an intra-EU context. So we're not dealing with data transfers, but within the EU. And there, the question that is dealt with high level is the question of whether EU member states can themselves do bulk collection and so forth. And there we have also a series of case law where the Court of Justice is repeating that we should make sure that there is more attention being paid to principles such as the kind of crimes for which such bulk collection can be used, retention periods, and so forth. So within the EU, we also have those kind of questions. And I think more generally speaking, that's also something that you can take into account. We're now very much focused on the US. Because we've had these revelations in 2010 that everybody still is remembering about Edward Snowden and so forth. But in the introduction, I was referring to the fact that we have a number of adequacy decisions also for countries like Israel. And I think there you could equally raise questions about whether their legislation is providing at this point in time, without wanting to do any political statements here. But the question or the point that I'm making is that the questions that we're asking, being the EU to the US, are questions that could also be asked to other members, to other countries as well.
Right. And final question, considering that there are alternative tools to facilitate EU-US data transfers in conjunction with the concrete framework that is the DF, such as standard contractual clauses, how will these affect the relevancy of the framework moving forward? Especially as been hinted by Julian, there is still that reluctancy in the take-up of this framework as well. So what do you see the impact of these alternative tools also having an influence on the take-up of the current framework?
Was that from? Okay, go ahead.
Yeah, I think it's a difficult question. I think something that would help the situation that we are facing right now, where there is reluctance, I would say, in general, vis-a-vis data transfers, which is also linked to the fact that, for example, we have recommendations of the European Data Protection Board of 2020 on supplementary measures that were adopted in 2020, and now we're 2024. And in those recommendations, you can clearly see that the European Data Protection Board is opening the door for maybe also other solutions, like more technical solutions. I think speaking from my practice, a use case in the recommendations that is often talked about is the use case 6 about SaaS solutions, where it's really difficult to transfer data in the clear, and where the European Data Protection Board is actually hinting that there may be technological solutions in the future and so forth. So what I'm saying here is I don't know if we can see an impact from one instrument on the other by the uptake by specific organizations. I think what would foster trust in this data transfer topic is maybe some new guidance from data protection supervisors.
Okay. Julian, any final thoughts?
Yeah, that's exactly what I was going to add. I mentioned earlier in the panel that following the release of the new SCCs in 2021, basically all of the supervisory authorities across Europe flagged that their view was that supplementary measures would be needed for transfers to the US in addition to the SCCs. I'm not sure that would be true anymore. I mean, we didn't really have many statements following adoption of the executive order, but it would be helpful, as Annalene pointed out, to have guidance on whether the supplementary measures, that were advised previously would still be needed, given given the changes to U.S. surveillance law under the EO, but notably following the adequacy decision, which is limited to transfers under the DPF, but the Commission and the EDPB in FAQs have said, have highlighted that the EO would apply to transfers using other mechanisms as well. And so I wonder if that view regarding supplementary measures for the US may be easing up a bit, and that we can only know through additional guidance or through regulatory action, which has not yet come.
Great. Well, I think we should leave it there as we have approached the end of today's webinar, but I'd like to thank our panelists, Ms. van der Meulenbroeke and Mr. Vermaat, for their insights and expertise into this important discussion. And thank you, our audience, for your participation and questions. Really appreciate it. We wish you all a wonderful week, and I'll see you all next time. Thank you very much.
Thank you.
Thank you.